we're talking about surveillance, and we're here with some men who are much watched, or who preside over the much watched. In the post-Snowden environment, how does the government's ability to surveil journalists and the legislation which gives them extra powers over journalists and their sources actually affect how journalists work and what we as citizens get to find out about and what we don't get to find out about? I've got three very good people to discuss this topic with me. Immediately on my left, I have Jason Bosland, who is Deputy Director of the Centre for Media and Communications Law at the University of Melbourne. He's going to give us an overview of the legal context in which we're talking. To his left, we have Michael Bachelard, who is the Investigations Editor for The Age, and in that role presides over the work of people like Nick McKenzie and Richard Baker, who've been much mentioned at different sessions here today as conducting many groundbreaking investigations. And on his left, we have Paul Farrell, who is a reporter at The Guardian in Australia, with a particular interest in immigration and national security, which has brought him a great deal of attention, not only from his readers. So, Jason.
Thanks, Meg. I suppose the first thing I'd like to just do before I sort of get into the detail of the law is sort of put it in context, in the sense that I can see that there are two almost opposing forces that are currently at play. There is a legal development in terms of journalist shield laws, which apply to journalists who have been asked in court to provide evidence as to their sources. And there are new shield laws that operate in various jurisdictions in Australia, which so far appear to be providing journalists, at least in the one case that we've actually had a decision, with greater protection than they previously did, and that's in the WA case involving journalist Steve Pennells. The other opposing force, I suppose, is the move by the current government to introduce data retention legislation, which poses all sorts of problems for journalists in terms of protecting their sources. That is a remarkable piece of legislation, and I'm going to outline the basic features of that in a moment. But just on the first topic, general topic, which is the protection of journalist sources in court. Previously, journalists were required to answer questions as to whether or not, as to their sources in most proceedings. The exception, I suppose, was what is known as the newspaper rule in defamation cases, where at the pre-trial stage, journalists didn't have to reveal, in most cases, the identity of their sources, unless it was necessary in order for the court to do justice. The second category of cases were pre-trial discovery cases, where, for example, this isn't a journalist source case, but it sort of explains what a pre-trial discovery application is. It's the Dallas Buyers Club type scenario where you go along to court, you're not yet suing anyone, but you're asking for information as to someone's identity so that you can then go along later on and sue them. Journalists generally aren't required to answer as to the identity of a source at the pre-trial discovery phase. So those were the two exceptions. Those exceptions, in those exceptions, it was a presumption of non-disclosure. That presumption has now been extended, if you like, to all situations where journalists are required to reveal their sources in court as a result of various amendments to the respective evidence acts in various jurisdictions, so New South Wales, Victoria, WA, and also at the federal level. That seems to be a positive development for journalists, and indeed in the Pennells case, it was said that one of the factors that really led the judge there to say, we're not going to require you to reveal your source, journalist, was the fact that it would have an impact on the free flow of information to the press, and that was definitely a weighty consideration. Now, that previously wouldn't have been the case, I don't think, if the shield law wasn't there. So that's a great development. We've currently got a case before the Supreme Court, the Modafferi case, which Michael might be able to say more about that. But I think the Victorian shield provisions, the new provisions, will be tested in that case, and we're likely to get a judgment, and hopefully the Victorian Supreme Court applies them in the same way as the WA Supreme Court in the Pennells case, fingers crossed. The second thing that I want to talk about, of course, is the data retention regime, which requires ISPs and telcos to retain metadata for a period of 2 years. that metadata can be accessed by law enforcement agencies. Now, the problem there, of course, is that if a journalist, if their metadata is accessed and it's able to be ascertained from that metadata the identity of a source, then there are concerns there. Now, that was raised as the bill was proceeding through Parliament, and certain amendments were made to the bill, including the introduction of a journalist's information warrant, a journalist source warrant. That procedure for obtaining a source warrant has some fundamental problems. One is that it's a criminal offence to disclose that a source warrant is even being sought or indeed has been granted to a law enforcement agency. So a journalist doesn't even know if their own metadata is being accessed by such an agency. The other is that there is what is known as the public interest advocate, who will put in representations as to the public interest in whether or not such a warrant should be granted. Again, the problem is that the journalist doesn't get to brief, if you like, this public interest advocate with information as to why that the identity of the source should not be disclosed. There may be genuine concerns, for example, about a source's safety. Now, it's not going to be clear necessarily to the public interest advocate that is the case. The other is the way in which the public interest advocate is appointed. There are concerns there as well. So there are real problems there. I don't think the checks and balances that that was sought to be made to provide adequate protection for journalists in that regime is really going to have much of an effect at all.
A pretty gloomy and worrying picture.
Absolutely.
In other words, Michael, how does it impact in practice?
Well, that's the interesting question, and to an extent, the relevant question is not so much will the law work. Will the safeguards make us safer? Because for one thing, we won't ever know whether those things are happening, and this certainly is the case under the ASIO Section 35P as well, where if a journalist strays into territory that they're not supposed to be in, they may never know that they're straying into reporting on a special intelligence operation. They won't ever be told until they find themselves facing a 5-year jail term, which they also can't talk about. So the issue isn't quite... these are obviously pretty draconian pieces of legislation, and they've come in under the kind of national security banner. But almost more important than the legislation itself, dare I say, is the effect that it has on both journalists and their sources. And if you deter sources from talking to journalists, you deter journalism. And if you deter journalists from freely inquiring into the areas of interest that they feel are important and interesting, then you stray into self-censorship. And when the boundaries of the laws, be it metadata or the ASIO Act, are so, well, they're secret. You don't know where they are. You can't tell if you're treading over them or not. The habit of journalists, but particularly lawyers and media organisations who have a lot to lose financially and in other ways from treading over that line that they can't see. The habit or what will happen is that people will tread cautiously, and that will deprive journalists and their audiences of the kind of inquiry that they need into these very important areas. I mean, we are putting more money and more power in the hands of departments like the Immigration Department and the ASIO and so on than we ever have before in the history of Australia. And we've set up a legislative regime where they will get less scrutiny than they ever have before. And I think that's the really worrying thing. So that's the effect on the media and media practitioners. The effect on sources is equally profound, because if you're a public servant, for example, or a police officer or a health worker in an immigration detention centre or something like that, and you've got something that's burning a hole in your pocket that you need to tell somebody because it's such a thorough injustice, and sources often come to us because they see an injustice. Very often they come to us because they want something out of it, or out of revenge, or there are positive and negative motivations. We don't really care as long as the story checks out and it's in the public interest. But either way, if they fear that their communications will be intercepted, their metadata will be traceable, or they might be themselves locked up, they won't come to us in the first place. And that's the kind of chilling effect that we will never know what happened. We won't even know about it, because it will be the phone call that didn't come, as opposed to the one that came and that produced a magnificent story that, you know, changed the way the law worked or whatever. And so we're most likely just not to know. And, you know, I preside over the work of Nick McKenzie and Richard Baker and others, a highly talented journalistic team. And, you know, Nick's very conscious of these things. He'll go to different desks in the office to make phone calls. I don't know if that makes any difference. He'll borrow other people's mobile phones. To the extent that I'm under surveillance, it's probably because he's borrowed my phone. You know, he uses WhatsApp and you know, various different kind of messaging, or you know, in the hope that this will sort of scramble the signal, if you like. But no matter what he does, it won't help if the source hasn't come to him in the first place, and that's what we refer to as the chilling effect. And I think that's really, you know, what we're looking at the moment.
Paul, let's hear from you.
Yeah, I mean, I think most of the ground has been covered fantastically by Jason and Michael so far. But I mean, I really agree. I think there are two really core issues facing journalists in Australia at the moment, and that is, you know, there is such a vast range of legal impediments put in place for the practice of journalism, and you know, it's not the sort of impediments that you might find in Iran or Iraq or you know, certain countries in Southeast Asia, but they are still very, you know, quite growing impediments to the practice of journalism and to serious public interest reporting. And I think the two of those that we've already sort of touched on are disclosure offences, and that's things like Section 35P of the ASIO Act, which prohibits disclosures of special intelligence applications, but that's also things like the new Australian Border Force disclosure offence, and the general catch-all disclosure offence under the Crimes Act that has been very consistently and heavily used over the last 2 years by this government, particularly in immigration, to refer journalist stories for prosecution. And those range of disclosure offences, I mean, what I say when I say it's a disclosure offence, but really it's a gag clause. And you can find in almost every parliamentary act that's relating to immigration or to defence or the ASIO Act or whatever, there is going to be a separate disclosure offence that in some way criminalises the disclosure of some form of information. And all of these in their aggregate have an extraordinary chilling effect on public servants and prospective whistleblowers who are considering speaking out. And the Law Reform Commission has very consistently recommended that there needs to be something done about these disclosure offences, but nothing has changed. And in fact, as I'm sure you're all aware, over the last few months, we've seen the Border Force disclosure offence come into force as well, which relates particularly to immigration and Border Force related matters. And we know that they have, that this, generally the way this has worked over the last 2 years is that there's a catch-all disclosure offence under the Crimes Act, and that's the one that's been used to refer stories to the federal police. And that's my stories. I think there's at least 2 or 3 of my stories that have been referred for an investigation to the AFP. That's journalists from news.com.au, from the West Australian, and
just
other
to be
reporters.
clear, Paul, they're investigating you or the people who provided you the information?
Well, to some degree, both. I mean, the disclosure offence under the Crimes Act prohibits the disclosure of information by people who work in those centres. But one of the issues that has consistently cropped up is, you know, whether journalists can foreseeably be seen as accessories to certain disclosures as well. And that's because these disclosure offences are so broadly crafted. That is genuinely, you know, a risk that we've had to discuss and consider, which is really worrying. So that's kind of the state of affairs at the moment with those disclosure offences, and they're enormously worrying. The second is, of course, the metadata laws. You know, even before data retention passed, this was an issue for journalists. It was not an issue that people talked about and discussed as much, but it was an issue. And what the data retention regime will do is ensure that a much greater set of data is possible, it can potentially be accessed by law enforcement agencies that could be used to determine the identity of a source. But I mean, out of interest, before the disclosure, when I realised some of these investigations were going on, and before the data retention laws passed, I FOI'd the AFP for any of the authorisations they had used to request my phone and web metadata, and they came back with the response they would refuse to confirm or deny the existence of the documents because to do so could compromise an ongoing investigation. So,
in other words.
So you can make what you will of that. It wasn't a particularly inspiring response to get. But you know, it is a massive problem. And I think collectively as an industry, you know, we all need to sort of get better at educating journalists and sources about these risks and how to resolve them. And I think that's kind of what was canvassed here. There's, you know, 3 ways to do that. And it's all an exercise in risk management to some degree, I think. But you need to, if you are a journalist, and, you know, I think probably a lot of you guys might be students out there and things like that. And, you know, if this is something that you think is important, the kind of 3 most important things you need to understand is firstly the legal framework in which we sort of operate, which is sort of what Jason has gone through just now. And secondly, the technical issues and architecture of the internet and of mobile phone telephony and things like that. You know, you need to understand what an IP address is. You need to understand how it could be used to locate someone. You need to understand what could be gleaned from telephone metadata. And then the third is, of course, you need to start getting familiar with those kind of counter-surveillance techniques that journalists are increasingly users, and to be able to determine, based on those kind of 2 prior points, what are the most important tools to use in particular circumstances. So that might be, you know, Signal or Wickr, or it might be Tor, or it might be using PGP or OTR chat, or using the Tails operating system. It'll all depend on the kind of scenario you're in. But I think we're in the kind of situation at the moment where it really is just critical for journalists to make sure they are developing these skills.
And that can be quite difficult to do. I know we've just recently taught data security skills at the university to our journalism students, and, you know, these are not skills that are just sort of lying around to be picked up, are they? You actually need a fair bit of speciality. But can we just look at it for a moment from the point of view of the source? I mean, you've talked about the chilling effect, but how aware of sources are sources of the sorts of things you've talked about? I mean, is one of the worries, for example, somebody ringing up Nick McKenzie on their own mobile phone, ringing his mobile phone, and not being aware that they've already, before they said a word, potentially compromised? Is that an issue, Michael?
Well, yes, it is. I mean, we saw the very controversial case in which that Cameron Stewart at the Australian was involved in a few years ago, where a source who was in the police made some calls or emails, I think, both, and those were very quickly identified. And Cameron was then put heavily on the spot to essentially confirm whether this was his source, and that was done under, you know, the prospect of coercive questioning. So that's that was perhaps a precursor of this kind of thing. I mean, when you're dealing with a government department or a security agency, they won't have to do what Antonio Madafri's doing and take the journalist to court to seek his source. They'll just go and get the metadata. And the journalist will never know. So the effect, it is already having a chilling effect. But sources, I'm aware that sources are aware of it. I don't know that they are aware of how to get around it, because, you know, the journalist can employ all the security they like, but if the source is not doing the same kinds of things, then they're vulnerable from the other end, because very often, in fact, there will be a suspicion that this is the source, or a small number of people are the source, and the agency can check it out from that end, not necessarily this end. Yeah. So, yes, I mean, I think the first prosecution, if and when it happens, will shut down a lot of people. And let's not be under any pretense here. The Australian government for decades, probably 2 decades now, has been one of the most restrictive governments, I would say, in the world, in terms of its how it allows its public servants to deal with the media. I recently came back from Indonesia, and a bunch of my colleagues from the US who were in the press gallery had all come to Australia to cover the search for the MH17, which was off the coast of WA. And they were absolutely gobsmacked and disparaging and shocked at the level of control that the Australian military was exerting on the reporting of that incident. They couldn't believe it, and we've become inured to it because that's what we face from public servants every single day. So, we've there's a bit of a boiled frog syndrome here, and I think, we're reaping the whirlwind now, having not really stood up before.
Now, I want to talk a little bit more about the politics of it and the why of it, but first of all, I was just wondering, Paul, can you take us into your life a little bit and actually describe to us how these issues affect you? And I'm not asking you to give away any secrets that you shouldn't, but how these issues actually affect you. I mean, what is your life like with this awareness of surveillance?
It is, it's definitely a somewhat frightening thing, when you have to sort of undergo raid training in the office just to refresh every 6 months what to do in the event that the AFP decides to bang down our doors. It's not a particularly nice thing to have to be thinking about, and to have to sort of think about, what, where I have materials, or whether I, or things like that. It's not a very fun prospect. And I have the same situation that Michael described, when you get a call from someone, and I think my first thought is, did this person use their real phone to contact me? And if they did, does that mean that this is the end of the story? The story can begin before it's even started, because you get this call from someone who calls your mobile from their mobile, and suddenly there's this red hot trail to this person that can be very easily tracked back to you. So those are those are the kind of everyday considerations that I have to think about, and require some very daunting considerations at times about what I sort of do to engage with people beyond that point. Sometimes you do get the sources who are more educated and better educated, and I think that is happening more, which is really fantastic to see. And when that does happen, then you kind of get situations where you might initiate communication using one of these some sort of application or tool that it would be much less easy to discern the kind of metadata trail from, and that's great when that happens. And then you can kind of go from there and sort of organise a meet that is, also in a relatively safe way, without taking your own phone to that and things like that. But it's just it definitely impacts on how you think about the world. And when you sort of walk into a room and it's like, how many electronic devices are there that can listen into what I'm saying? And probably does, definitely adds an element of paranoia to the way you think and the way you engage with people.
Because let's be clear, it's possible for a mobile phone to be on even when you think it's off.
Yeah,
it's
absolutely.
possible for it to be listening to a conversation even when you think it's off.
Yeah.
Yes.
Yeah.
And what else that we normally carry around with ourselves carries computers that can potentially be tracked? Let's try and catalogue it between us.
Well, you've got your lovely little Apple Watches, and I'm sure some of you have, and all all sorts of car GPS tools. Is a hilarious example, well, not very hilarious example, but a few years ago, Mark Davis, when he was on Manus Island, had a fixer, and they hired a car, and the GPS on the car was used by some G4S guards to work out where he was on the island. It's and it really makes you think about just what the things that are around you. The CCTV, your Opal cards, or what do you call it, Mikey cards? That's what you call Mikey cards, and all those sort of things.
Except they don't work, so they're all right.
Well, that's fine. It's fine. And how you can use them. So it definitely shifts the way you start to think about the world in a not great way. But you also just have to accept, and it's just kind of become this weird. I didn't really expect my life was going to be like this. I almost became a lawyer. I wasn't actually going to go into journalism at all. I almost became a media lawyer, and I sort of fell into this job. I kind of wonder what my life would have been like as a lawyer sometimes.
And Michael, tell me, if you wanted to meet, say, me in Melbourne somewhere where nobody would know that we had met, where could we go?
Well, I wouldn't recommend the Age Cafe.
Damn. Such good coffee.
It's good coffee. Look, I don't think it matters to me so much where, as long as it's discreet. It's what you bring with you. And as you were saying, the mobile phones and so on. You wouldn't go to the Celtic Club, which is where the cops hang out, or at least that's where they used to. but I've met people at the Geelong service centre on the Geelong Road. I've met people in on rooftop bars and things like that. And so I mean, there's you gauge the danger as well. I mean, I don't predominantly write in my own journalism, my own reporting on security and issues like that. So the people that I'm generally dealing with are members of the public, and for those people and dealing on a non-security issue, I don't employ any of these counter-surveillance measures. But the Guardian has, and the Age is in the process of setting up secure Dropbox type arrangements, WikiLeaks style, so that you can, and you can get stuff anonymously still, but it's got a couple of downsides. One is that the user at the other end also needs to act in a secure fashion, and secondly, as I understand it, it anonymises it to the point where you actually don't know who the source is. So you've then got to apply a discount to the information you've got, or you've got to try and find other ways to verify it. Otherwise, it's just a piece of, it's a shit sheet, it's a scurrilous thing. So there's no kind of perfect way around the idea that you're being watched all the time. And I think ultimately it'll really be really interesting to see how it pans out, how enthusiastic these cases are prosecuted and so on, and what journalists and media organisations end up doing about it. It might be just one of those things that you become fatalistic about as a journalist and say, well, as we were fatalistic for a long time about sources in general. Before the Shield laws came along, it was the case that if we didn't identify a source, we could be held in contempt of court and sent to jail, and journalists were jailed for that. And I know that most journalists would have been quite proud and honoured to be sent to jail to protect a source, because it would have said something about their integrity and their trustworthiness and so on. So there's a curious kind of sort of chest-thumpingness about we journalists that I suspect might ultimately reassert itself in some ways.
Yeah. And Jason, I wonder if you can cast some light. I guess one of the big questions is why? Is this a legal or a political issue, or both? What is driving these
both,
laws?
because I was, just as the others were speaking, I was sort of thinking about, how would this play out in the US? I mean, you mentioned US reporters coming over to cover the plane crash. Certainly in the US, the constitutional framework there has a big impact on the law surrounding journalist sources. I mean, they're basically, not required to reveal sources. In Europe, there's been a big swing towards greater protection of journalist sources, not through any formal change in the law, particularly in the UK, but certainly as a result of the introduction of the Human Rights Act and the greater recognition of European human rights standards within the domestic courts in England. So Article 10 of the European Convention on Human Rights, I think, has had a big impact on the protection of journalists and the way in which courts go about balancing the competing interests. And I think much greater weight is given to freedom of expression, and much greater recognition is given to the importance of journalist sources to freedom of expression and the role of the media than we have in Australia. And I think because we don't have that strong constitutional or human rights framework in this country, that's certainly something that I think leads to what we're seeing now. I mean, what would be really interesting is if the Data Retention Act were challenged in the High Court on constitutional grounds for potentially being in breach, if you like, of the implied freedom of political communication. Could it be struck down as being unconstitutional in its current form? I think probably not. But there is a real issue there about whether or not it is proportionate. Is the journalist information warrants regime proportionate? A proportionate imposition on the freedom of political communication? Because no doubt this will have an impact on political reporting. So it clearly falls within the scope of the implied freedom. But the question is the proportionality of it. So I'm not quite sure how that would play out, but it would be interesting to see Yeah.
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 I mean, I guess what lies underneath a lot of this is fear in the post 9/11 environment, fear of terrorism, and of course this has been in the headlines in very recent hours and continually over the last few years. What is an appropriate balance? I mean, there is a public issue safety.
No, that absolutely is. I mean, one of the things I've been looking at recently in a different context is the definition of national security as a legal term. What is that? What is national security? How do you define it in law? And what was really surprising to me is that basically national security can either mean anything you want it to mean, and certainly over time, things which are accepted as falling within the scope of national security has expanded and expanded and expanded. So, early on, when national security sort of was first being used as a term of art, if you like, it was limited really to hostility between states.
Yeah.
It's now, things like food security falls within, national security. Now, you can make an argument that anything falls within national security. International relations has recently been held by a Victorian court to essentially fall within the scope of national security. So just having good relations with other countries. So I think there's definitely a problem there about how you go about balancing those interests when you don't even really have a legal definition of what national security means. It's one of those terms that can be manipulated.
And so national security might include water supply, food supply, climate change.
Yeah, absolutely. Yeah, all those things. Food security. Yep.
Almost everything.
Yeah.
Actually, some people in this room might suggest that that's a better definition than the one we currently have. and I say that seriously because, the issue of a lone teenage gunman outside a Parramatta police station, while a dreadful incident, and while politically motivated, and I would probably call it an act of terrorism because of the political motivation, yet the outcome was one civilian died and one gunman died. And that kind of, in terms of scope, that doesn't make it any different really from a murder-suicide in a domestic violence situation. And yet we don't have metadata, retention and all these kind of heavy-handed legal changes to try and deal with that. We have it for the lone gunman outside the Parramatta police station, and that's a national security issue. Actually, I don't think it is national security. It might be terrorism, but it's still pretty local. It's local security.
Funnily enough, actually involved in some proceedings at the Administrative Appeals Tribunal that have just started, where the Immigration Department is taking me there over an FOI lodged on boat turnbacks about 18 months ago, and the Information Commissioner ruled that some of the documents were national security exempt under the exemption under the FOI Act that allows that, but one of them should be released. And on that one single document, the Immigration Department so desperately don't want me to see it that they're taking me to the AAT, and it's going to kind of be quite an interesting sort of test case about the application of this idea of national security to our asylum and immigration policies.
I mean, courts either say national security is so obvious that we don't need to define it. I mean, that's, from the case law that I've looked at, they just don't define it. Whereas others have said, that it can include quite broad things. But there's no sort of kernel in terms of what it means. But the other thing is there's just this general deference to the executive in when the matter is being determined by a court. The court will defer to what the affidavit of, whoever it might be, the ASIO officer, whatever, as to whether or not the disclosure of particular information would pose a national security concern. And there's no actual scrutiny as far as I can tell, although a lot of this is conducted behind closed doors, so you don't actually know. The degree to which the judge actually comes to their own conclusion as to whether or not this information has any sort of national security concerns in terms of its publication. So there is that sort of deference. So it means whatever the executive says that it means in a lot of cases.
That's interesting, and you get that played out also in the media debate. And in a recent speech, Laurie Oakes complained about an editorial in The Australian which had attacked him for making a comment about national security and likened him to the Greens, which he rightly pointed out in The Australian is the biggest insult in their armoury for questioning this. So the idea that the executive and a portion of the media and a portion of the political class will sit on you if you start talking about something that has been defined by the executive as national security, it is, it's a real issue.
Yeah. Now, we've been talking so far about the law, but one of the imports of the Edward Snowden revelations is that the US authorities, at least, and some others, haven't obeyed the law in their surveillance practices. How confident can we be that the Australian government actually obeys the law?
Can I just say not at all?
Well,
Yeah,
you go, Jason.
yeah.
Not at
That's all I could say. I mean, I
You
don't,
wouldn't know, though,
we don't
would
know. I mean, you don't know.
How could you tell?
Whether they're obeying the law or not. I mean, to be honest, there is a mechanism for judicial review for some journalist information warrants that are sought. So there is some mechanism for judicial oversight. However, I mean, again, it's the court, taking the word of these enforcement agencies, and they tend to defer to them. So there is a legal mechanism in some instances where it can be reviewed.
Paul, I think you wanted to buy into that.
Yeah, well, I mean, I think in the context of the broader sort of international surveillance apparatus that we now know exists and that we now know Australia willingly and quite actively plays a role in, it is, it's firstly impossibly hard to work out exactly how Australia complies with a lot of their obligations. I mean, we reported on some of the Snowden documents that pertain to Australia's surveillance activities, and they did seem to raise, quite a number of concerns about our potential bulk sharing of metadata overseas and things like that. But irrespective of even whether or not you can sort of pull back the veil on those issues, I mean, the second is that unlike the US, where they have a very strong constitutional framework, and unlike the UK, which has a much stronger regional framework and also this kind of this domestic implementation of a human rights apparatus that is much stronger than Australia, we really have fuck all. It's just there's just nothing. You've got a constitution that provides for freedom of religion, and that's about it. And no kind of domestic Bill of Rights, no real mechanism with which people can enforce basic rights and protections. And, I mean, if you look at, there's various, there's privacy rules for the Defence Signals Directorate, so the Australian Signals Directorate, that says, when they can target Australians and things like that. And they're incredibly vague rules that are full of caveats and all sorts of things. So they're weak as it is. And then the only people that really police them is the Inspector General of Intelligence Security, which has a staff of about 20 and oversees tens of thousands of security agency personnel. So it's not altogether inspiring, but that's what we're here for. We got to do that work. We got to do the hard yakka and find out what's going on. Yeah. Get back to you on that. Yeah.
Well, I hate to end on a gloomy note or a hopeless note. What should we do as citizens, as journalists, as lawyers? What can we do? Jason?
Well, I plan on doing some empirical research, so I don't, if I can. From my perspective, I mean that's where my research is heading, is sort of looking at institutions of government, including the courts, and looking at their practices in terms of transparency. And so this is definitely something that I'm interested in exploring further. And the difficulty is getting access to information, and I found that even with the courts, and that they're probably the easiest of all of those institutions from which to get information. So I would imagine it's going to be pretty hard, and I think probably it has to be done through interviews with people, so interview-based empirical research rather than other forms of empirical research.
And when you have done that research, will you be seeking to bring it to public attention through the media?
Oh, of course.
And thereby potentially coming under surveillance yourself.
Absolutely. Yes. And look, I think there's a real role for academic research in affecting legal change, at least, in this space. Indeed, that happened with the Open Courts Act. There was, academic research led to aspects of that act coming into force. So I think there's definitely scope for that. There was, however, political will there, which, there's probably less likely to be in things like the data retention regime. So,
Michael, what can Fairfax Media do, but also what can citizens do, the audience?
Oh, we can tell yarns, mate. Look, I think that's what we're here for, right? So that's what we can do, and if we have to employ evasive techniques to get around the new laws and still meet people and still get stories. There are still people who are remarkably, I think Paul will agree, people who are willing to talk, people whose consciences or whatever, the positive or negative I'm trying to look for the word, I can't find the word. Motivations brought them to us, have always brought them to us, will continue to bring them to us. We just might need to be a bit more clever. But the media's been, Laurie Oakes in his speech was a very good speech, I'd commend it to anybody who wants to read it, was critical of the media also for having been asleep at the wheel. And we, I don't know, through inattention or bluster that we thought, it wouldn't affect us really or whatever, we kind of didn't kick up a stink about this stuff. And he's right, with some honourable exceptions, I must say, including Bernard Keane at Crikey.
Yes.
But we need to, I think, keep doing what we're doing: expose, report, investigate, and embarrass.
Anything to add to that list?
Yeah, I think I'd largely echo Michael's sentiments as well. But also, I mean, just it's so important, particularly for you guys in this room as well. I mean, to learn as much as you can about all of these kind of tools and things like that. There's still a huge deficit in most newsrooms, a sort of skill deficit surrounding a lot of these counter-surveillance things, generally across the industry and generally across the community as well. So, like, if you're interested in it, just start learning. Go to the Freedom of the Press Foundation, go to the Electronic Frontiers Foundation websites and start kind of seeing what different tools you can learn about. Most of them are all free to use, and build those skill sets. And then if you want to go into reporting, then keep sort of fighting and engaging with these issues, because they're these these are the kind of defining issues for the next generation of reporters. And I guess another thing is, like, to only do it if you really enjoy it and have fun with it. You've got to enjoy fighting. I think that's a pretty critical part of being a journalist or sort of an activist or if you're in the law and you're kind of interested in these areas. You have to really love it. So yeah. That
may mean you have to be a slightly strange person, Paul, but anyway, we'll see. I want to open it to, I have many more questions that I could ask, but at this point I'd like to send it to the audience. We have one from Bill Bernbard on the front here.
Thank you. I'm kind of interested in where's the line between, quote, responsible journalism and, quote, independent journalism. And what prompts me to ask that is that you referred to the Cameron Stewart case. The Australian put out a press release saying that they had held the story as the AFP had requested for about 5 days, I think it was, and let the AFP actually vet the story before it was published. And that was an example of responsible journalism. So I'm just wondering, particularly with Michael and Paul, I mean, how do you draw the line between reporting something that may impinge, quote, national security, that may put lives at risk, and yet be an independent journalist?
Look, I don't see a huge problem in that, and I think it's a question of judgment on a case-by-case basis. I'm not old enough really to have been around where D notices were being issued, but in the old days, when the national security was in question, the government would say, no, you can't report that, and they'd either threaten or issue a D notice to say national security can't report. And what, as I understand it, that usually led to was a process of negotiation between the newspaper and the government agency, saying, well, can we report this? Well, what about that? How about if we say this? And as I understand it, and I stand to be corrected, very few D notices were actually ever issued. It was it was more about the kind of, we're in tricky territory, let's have a discussion. And I actually don't, as long as both parties are acting responsibly, I don't see there's any problem with that, actually, because journalists, we want to push the boundaries, but we don't want to put lives in danger, and particularly not carelessly or thoughtlessly or without knowledge of what we're doing. And so if somebody comes along and says, well, actually you are, then, I think we can and should be responsive to that.
Paul, you agree with that?
Yeah, largely. Yeah, I mean, I'm not entirely familiar with all the details of that particular case with Cameron Stewart, but yeah, I mean, I think if there is and I kind of prefer the approach that the US sort of takes in terms of the permissible limits of speech generally. But if where there is a real risk of harm flowing from a disclosure, then I think that is what should give reporters pause. With how and exactly when they report on something, and I think that's largely what Michael was just saying as well. So yeah.
Jason, do you have a view on that? To what
I
extent?
suppose the other thing I was sort of thinking was, there is this sort of responsible journalism, and there's responsible journalism, and the way the courts approach it, because I always think about, the legal side of it and what the courts say. It's really easy for a court to look back in hindsight at the conduct of a journalist and say that was irresponsible, that was, not proper journalistic practice, whatever it might be. And I think there needs to be given greater latitude for journalistic behaviour in determining things like responsible journalism. And I don't, and this goes beyond the national security context. It also goes into the defamation context. I mean, we saw it in the Joe Hockey case, where while the articles in question in that case weren't considered to be defamatory, the judge considered whether or not the responsible journalism defence applied, or the reasonable journalism defence applied. And the degree to which the judge in that case went over the conduct of the journalists in sort of almost forensic detail was quite astonishing. So yeah, I mean, I think that's a concern as well. And I think also that in the current climate, the media's had a bit of a bad rap in the past few years, internationally and also locally. I mean, you've had the Leveson inquiry, you've had the Finkelstein inquiry here. And so I think probably in that context, I think that probably explains at least some of what we're seeing now.
I think that's right. The sort of nirvana of the de-notice nirvana I just outlined involves us trusting them and them trusting us, and I think that's
well,
pretty
we have
shaky.
been carrying on here as though all journalists behave in a professional and ethical and responsible and publicly interested manner. And of course, that hasn't been the case in recent history, has it? Journalists have actually been the surveillors, and in breach of the law in doing so in the UK.
That's right.
Yeah, and that does form part of the context. But we'll take another question. There's one in the middle and one down the front.
Thanks. Hi, so I'm a French journalist, and in France we have Mediapart, I don't know if you know it, which is a 100% independent investigative media. And I was wondering, here in Australia, is it possible to create this media? Like, I feel it's very much needed.
How's it funded?
At the beginning, 5 or 7 guys from Le Monde, they left this traditional newspaper, they put money at the beginning, and then it became truly independent with the subscribers. They have more than 100,000 subscribers right now in France. I'm one of them. And it's like when I arrived in Australia, I was trying to find the Australian Mediapart, honestly. And I didn't find it.
Yeah.
So.
Well, we are, as one of the Fairfax CEOs famously put it, an advertising platform and content providers for an advertising platform. And he was a most inspiring leader, I must say. But yeah, I mean, we are in a sense slave to our commercial, to our salaries at the heart. And in Australia, I don't think you could find 100,000 subscribers to support a purely investigative media. I mean, I've written a couple of best-selling books, and they sold 8,000 copies each. That's a bestseller in Australia. It's a small market. You can't niche market really here, and so it makes it difficult to run something like that. I mean, ProPublica I think is quite successful, but that's funded by philanthropy basically, isn't it?
And I work for a British newspaper, so I can't really contribute to that.
Well,
I might actually just talk a little about this because it's one of my areas of research interest, but there have been an attempt at a philanthropically funded outlet, the Global Mail, which was funded by a philanthropist called Graham Wood, which sadly failed when he pulled out his support, largely, as I gather, because it had failed to gather a significant audience. But there are some signs of crowdfunding as an effective way of raising money for particular kinds of journalism. For example, the Indigenous X Twitter and social media presence has just run a very successful crowdfunding campaign. The Conversation, which publishes university research, raised, I believe, nearly $1 million through a crowdfunding campaign. And there's also an outlet called New Matilda, also web-based, which I think somebody who was here from it yesterday has said it's surviving on the memory or the desire for an oily rag. But nevertheless, crowdfunding has been part of the story there. And of course, in the United States, there are philanthropically funded newsrooms such as ProPublica, and there's an expert on them sitting 2 rows behind you. I'm supervising his PhD thesis, which is all about that. So there are some signs of things happening, but yes, not on the same scale that you're describing. Does anybody else want to add?
I'm curious, I haven't heard of it. Is it a one-off in the world? Are there others who successfully have subscription models that you know of?
I know Mediapart, at least, and yeah, in USA it's more philanthropic stuff. But the more I try to understand how it works here, the more I feel like all investigative journalists here in Australia should gather and try to do it. Like, that's something to do.
Anyway, we'll take another question.
You've painted a fairly Orwellian landscape for readers and citizens and for journalists, especially Paul. But Michael, I know you've worked in West Papua and Indonesia, which for activists of that particular struggle, it's a pretty Orwellian landscape as well. Is there a difference between what you're finding here with this hidden surveillance and the very overt surveillance up there when you did a couple of research stories on orphans being kidnapped by Indonesian military and stuff?
Yeah, I mean, you know, it's probably overstating it to say that West Papua is a police state, but it's certainly there is a heavy police presence there and a very overt one. And the people who are doing public service journalism there in West Papua do feel certainly as if they're running the gauntlet every day. And yet, you know, there is in Indonesia a curiously open media environment. The problems there are much less the state interfering actually than the proprietors who tend to be themselves politicians. It's quite a different model, but democracy in Indonesia generally has brought a very open media landscape and quite sort of lively. Yeah, not perfect, but not bad.
Another question? We've got one down the side here.
I was curious how successful systems like Secure Drop that you were talking about, The Guardian has, and I think The Age is implementing. Like, how often do they actually get used? Just looking at them, it looks like there is quite a technological literacy barrier to actually using them. But yeah, could you share about that?
Unfortunately, I can't really say how often they're used because that might give a little bit too much away. But, you know, people definitely use them. People definitely use, you know, our Secure Drop system, which is great. The technical barrier to use it at a kind of base level is actually not that high because it largely, I mean, basically the threshold step to using it is to download the Tor web browser, which is, you know, a relatively straightforward thing to do. You know, you can, and that's to kind of use it with a degree of security. You know, there are always going to be risks when you're just using Tor on a regular computer. So we also recommend a sort of using a high level of security, which would be using the Tails operating system, and that would be harder to set up. But to use it with a, you know, relative degree of security by using Tor on a desktop device is something that I think a growing number of people are becoming accustomed to, you know, and using Tor and VPNs. I mean, how many people here use either a VPN or Tor or both, or show of hands? Well, that's very uninspiring considering you're all at a surveillance and sources event. Shame on you. God.
Well, I should say we recently had a weekend's intensive workshop at the University for Journalism students in the use of these tools, and of course it's a moving target all the time. We looked at Cubes as the operating system of choice.
Yeah. Cube's pretty fascinating. Yeah, it's an interesting.
But anyway, we could get all techie here, but I suppose part of the question is that journalists have to. We've got time for probably one or maybe two questions.
On Tuesday night, I went to a crypto party, which
Sorry,
was...
you're going to have to speak up a
sorry. That's better. I went to a crypto party, which is originally founded by Asher Wolf, I think, who sort of created this idea that you could go along to these courses and, as you were saying, learn about the different software available to encrypt messages and things like that. But one of the things that became pretty apparent was that it was very difficult technology to use for someone who might not be aware of how to sort of use anything beyond email, or when a source, has limited means of communication if they're in detention or in some sort of circumstance like that. I wanted to know how you think we could educate sources and I guess the wider public in sort of knowing how to use those services, and if that's even a possibility, or if we'd have to go back to sort of using telephone booths and things like that.
Well, I might have a little bash at that because it's a question I've given a lot of thought to as a journalism educator. I mean, I do think, and media organisations are beginning to do this, there need to be instructions on the website in how to talk to media organisations securely. And I do also think that journalists all commit themselves to protecting their sources. This is absolutely part of that ethical commitment, and something which journalism educators have to teach as a priority. We're certainly beginning to and planning to do more of it. And journalists have to see it as an extension of their ethical duty to their source. That's my view, though, and I'm not meant to be talking so much. Gentlemen, would you like to comment on that?
Yeah. I mean, I think I completely agree with you, Margaret. I mean, I think that it's got to be a process of education. I mean, I've run a few courses on this sort of stuff as well, and I hope to do more of them too through The Guardian. And but it absolutely is something that can be taught and understood. And it's always, I mean, at a very base level, if you manage to get your sources to use Wicker or Signal or one of those kind of what's called an over-the-top app with a relative degree of encryption and security, you're still doing miles more than if you were just communicating with someone via text message or via phone. You're significantly reducing those kind of risks, and that sort of thing is quite easy to educate sources in. And I think that's a really practical thing that most of my traffic goes through one or two kind of applications in that sort of space, and you're really going to reduce. I mean, there's a reason why, as an illustration to this, there's a reason why in a whole bunch of the control orders that have been issued recently, one of the controls listed that these guys are not allowed to do is use any VoIP service, basically. So it lists like WhatsApp, Viber, things like that. And the reason for that is because the police can't crack it, and it's not they can't crack it, it's very hard for them to crack it. If you're getting into really hairy intelligence style stuff, I would say all bets are off, and you definitely can't guarantee security. But the threshold of risk is significantly reduced if you're worried about the AFP snooping around, if you start using applications like that.
Yeah. Just brief comments, gentlemen, because we're nearly out of time.
I'd say that there's another aspect to this. This is a big challenge for journalism companies who generally, run the equivalent of mainframe systems with, one operating system that they bought from Microsoft or whatever, and nobody's the administrator of their own desktop. It's all done centrally, and so on and so forth, for people to actually be flexible enough to download and use these kind of browsers and so on. I personally on my work laptop find that virtually impossible. So organisations have to respect that commitment, and they have to change as well, and that's actually for them is going to be a big issue.
Please join me in thanking our panel.